Good afternoon, everyone, and a very happy new year to all of you. Today is January 19th, 2023, and this is our bi-weekly community conference call. We hold these community conference calls every other Thursday. I'm going to answer your questions subject to the disclaimers that you heard while you were logging into the conference. First, I'll go over the questions I consider to be frequently asked questions. I have a lot of them today. At the end of each question, I will ask you to respond if you have a follow-up question. And then I'll do the other questions that are not frequently asked. And finally, if time permits and there are other questions beyond what has been posted, I'll do my best to answer them as well. With that, let me just make sure that you can hear me okay. I was going to get started.
The conference is now in conversation mode.
Can you all hear me okay, guys? Am I coming through okay? Can you all hear me? Hello? Can you hear me, guys? Yes or no? Hello?
Yes.
Okay, thank you.
The conference is now in presentation mode.
Okay, let's get started. The first question that I have marked as a frequently asked question asks me, can I enter the United States on a visitor visa while my green card is pending? And the answer is yes. There is no law that says you just cannot, but as a practical matter, because non-immigrant visas, not all of them, but most of them, require you to have a non-immigrant intent, which means I don't want to get settled in the United States, they won't give you easily a visa like a tourist visa, a business visa, or a student visa, or a J visa, where you are required to have non-immigrant intent. But by the way, I am a prime example myself. When I came to the United States on a student visa, my green card was pending. So that goes to prove that it is not absolutely forbidden. If you can convince the consulate that you are indeed going to obey the law and going for a short trip, you should be okay. So I'll give you examples of many cases where we've had US citizens sponsoring a spouse, and the spouse wants to come and stay with the US citizen. They've gone and gotten a tourist visa, and they've been able to visit and stay here for many, many months. So it's not like there is a blanket bar against it, as long as you can convince the consulate. But then comes the next part. How about visa waiver? So what is the difference between visa waiver and a normal visa? In visa waiver, you have to convince the Customs and Border Protection at the airport that you should be allowed to enter. So what's a smart way to do it? If you're coming from Europe, come through Ireland, because there are in Ireland, I forget, it's Dublin, I think. At the Dublin airport, they have Customs and Border Protection right there. They will decide whether you can enter the United States in Ireland. So you don't have to fly all the way to USA to be turned back. So you can certainly try. If you can convince the government that you are not a person who is at risk of breaking the law, they might let you enter. No harm in trying that. The interesting thing is, for HL or O visa spouses, or people on H1, L1 or O1, this is no problem, because these are dual intent visas. They allow you to come into the United States even if there's a green card pending. Okay. So the question, they had posted, this gentleman or lady had posted a link to my earlier conversation, which I don't know. I haven't heard that, sorry. But you asked me, have any rules changed regarding getting a spouse visa through H1, L1 or O1? Nothing has changed. Is traveling to tourist visa after marriage not okay? It certainly is okay if you can convince the government that you are not going to break the laws, which means stay in violation of your visa. Does the US have any special agreements with the UK, I guess European Union, Singapore, Dubai, or Australia for visas that may qualify? There are only two kinds of visitor visas, regular ones and visa waiver or ESTA visas. Same thing, right? So there is no third kind. But there are special visas. For example, for Australia, there is something called an E2 visa. E3 visa, which is like an H-1B, very much like an H-1B. And that is also a dual intent visa. Okay, more or less, let me not just be that clear, but more or less a dual intent visa. Okay, so that's the way I see the law, and that's the way you can conduct yourself. Press *5 on your phone if you have a follow-up question on what I just discussed. Please press *5 if you have a follow-up question. Reserve your new questions to the end of the call. Okay. Next frequently asked question. Qualifying for EB-1C green card by working abroad for a year. Can this be done? Sure. We do it all the time. So let's say we have a person in a senior capacity, managerial or executive capacity, and the company has a branch in Canada or in Mexico or India or Dubai or anywhere in the world. Now, Dubai might be a little difficult. The rules are different there. But US laws are the same. So anywhere outside the US, if your company has a branch and you go and work for that branch or parent or sister company for 1 year as an executive or managerial employee, you can be brought back on L1 and converted to an EB-1C, or you can directly apply for an EB-1C come when the green card comes. The reason EB-1C green cards are so attractive is because you are done in a year or two instead of waiting 14, 15 years. So EB-1C is definitely an option. We do it all the time. It's a great option for many people. Then you wanted to know the expected processing time. So there's a difference between processing time and wait time because of the priority dates. So technically, EB-1Cs have been running, not always, but most of the time current, and their speed is almost as fast as getting married to a US citizen, 1 to 2 years. That's the typical. Okay. So let's see what the question is. Working in the US on H-1B, approved I-140 7 years back in EB-2. Oh, by the way, one more thing I want to comment on. Remember, priority date from EB-3, EB-2, EB-1 can be interchanged. You can take the EB-3 priority date to EB-1, EB-1 priority date to EB-3 or EB-2. This is the way it works, completely interchangeable. Okay. So with just 1 or 2 employees, senior resources, example, VPs or AVPs in financial domain reporting to me, what are the chances of getting EB-1C approved? Well, I count people directly reporting to you and then people reporting to those reportees. I think all of those people are subordinate to you. So it's a very difficult question to answer in the abstract. In EB-1C application, there is no premium available. It's coming up. Premium started, I think, January 30th? Yeah, EB-1C premium has started. It's going to start in 11 days. So that question is irrelevant. Do you see EB2 India touching 2015? Sir, I don't know. I don't think I can predict that. I don't think anybody can. It's all statistical. And there are so many variations possible. Okay, *5. If you have a follow-up question, press *5. All right. This is a new one on me. Consequences of employer withdrawing I-485 supplement J. So, first of all, I've never seen that happen in decades of my practice. But can it be done? Sure, employers could do it. Why not? Does that affect you? Eventually, all you will need to do is either file another supplement J through another employer or wait until you get a notice of intent to revoke 485 from the USCIS, which is what they will send you. If they are being kind, they might send you an RFE saying, provide us another supplement J. So it's not the end of the world. Let's see what you're saying. Currently working with employer B. Your EB2 was with employer A. You filed 485 with employer A, 485J, you were going to join them. But we couldn't find a new project, so he mentioned he's going to withdraw the 485J. Now, I think that's just being mean because it's not required by the law. Will it be a right-of-way denial, RFE, or NOID? So good question. Probably an NOID. And if USCIS wants to be nice to you, they'll send you an RFE giving you more time. If USCIS issues RFE and the response date is after 180 days, can I provide? Yes, you can. Because once the 180-day period is over, see, that's already September 2022. That means you have to wait till April 2023, right? Oh, damn. Yeah, October, November, December, January, February, March, April. That's the 7th month. So you have to wait 180 days from the date of filing. And after that, you should be able to submit any employer's 485J. Okay. I hope that that helps. Star 5, if you have a follow-up question, Rajat, press star 5. All right. Let's go on to the next frequently asked question. Another one that's very common these days. I get laid off while on an H-1B visa. Another frequently asked question. What if I cannot find a job in 60 days? Well, USCIS itself has said, which is interesting because many years they kept telling us you can't apply for a business visa or a tourist visa. That's not the appropriate use. But here, in one of their listening sessions, USCIS itself said that you could apply for a tourist status or a B1 status, B1, B2 status. So what does that do? That keeps you legal until the decision is made. That could be several months. The problem is if you find a job after the 60-day grace period is over, even if you get an H-1B transfer, when you get an H-1B transfer, you will have to go outside USA and come back in. Chances are you won't get status within the United States. At least that's typically what the government has held so far. I hope that helps. Star 5. Oh, wait, let me just also read this. I'm actively seeking. Do I have another option? Do I become out of status? But if you file for B1, B2, and you can do it online, you don't go out of status. Do it within 60 days. Does my visa become invalid after the 60 days? No, it does not. It does not. Can I reactivate it? Well, that's a little, I would want you to talk to your lawyers. I think it's possible because there's a section of law called 222G, if I remember it correctly, which says that if you violate your I-94, your visa is automatically cancelled. So have a conversation with your lawyers if that situation arises. But I think applying for a tourist visa is probably a good strategy. Or tourist status, I should say. Star 5, press star 5 if you have a follow-up question. Okay. Next question is extending green card while applying for naturalization. So here, situation has changed a couple of months back. Now the government says, if you apply for naturalization, even in the last month of your green card, we will send you a receipt that says your green card is extended for 2 years. With that receipt, you can work, you can travel. So you need to have the receipt and your green card. So don't chuck your green card out. You need to have the receipt and your green card. So naturalization receipt and green card, you can travel with that, you can work with that. Okay. So let's see. Is it okay to apply for citizenship now? No, you should apply as long as you apply within the life of your green card. Would any part of the green card number change when I get it renewed? That's not relevant anymore. I've already answered these questions, Balaji. So the other FYI points are not really relevant. If you are here and you have a follow-up question, press star 5. Okay, this one is from New Jersey. Yes, sir, I can hear you. Go ahead, please.
Thanks, Rajiv, for taking time to answer questions.
Sure.
Yeah, so I heard your answer. So I did not know that they will send a receipt.
Yes.
So that I don't have to renew the green card.
Yeah, they changed that just a few weeks back. It's new.
Oh, it is new. That's good. Because I was checking the green card renewal process, and they say like 20 months processing time.
Yeah.
So I still have like 8 months left.
Plenty of time.
So if I apply for the naturalization, the receipt will come in what time frame?
Usually within 4 or 5 weeks.
Okay. But that receipt is good enough for me to
That
continue
receipt,
on until
that receipt will notify you that with this receipt, you can both work and travel as long as you present your expired green card with it. Because this receipt will extend your green card for 2 years.
Okay. Great.
Okay?
Thank you so much.
You're welcome. Good luck.
Thank you.
Okay, let's go on. This actually has two sets of questions, one from the original poster and one from Vignesh. So I combined the two because the ideas were quite similar. So you're on H1B. Then you filed for a transfer. The other H1B approval also came. What is the risk? Under immigration law, there is no risk. You have a choice. You can work with the new employer, you can continue working with the old employer. Immigration law has no demands on you. Just because a second H1B is approved doesn't mean your old H1B is revoked, cancelled, or overruled. They both continue to be in force, but you have to choose one or the other. Okay. Can you join late? Can you join 5 months? Sure. 6 months later? Sure. As long as the new employer has not revoked your H1B, I don't see any problem with it. If they are making accommodations for you, you say, I have a project to complete with the old employer. I can't join right now. I think it's fine. Okay. So, I think all of this is it required to withdraw all approved H1B petitions? No, you don't. No problem at all. Let's go over to Vignesh's questions. Vignesh is working for a company A in L1A, which is good till 2024. I-140 and EB2 approved. 2019 priority date. Company B filed my new H1B. My H1B petition and accompanying request of change got approved on December 21st, 2022. Employer B shared the approval copy only on 29th December. I-94 is valid from December 21st. Will my work authorization status in US reflect as H1B only if I submit my new form I-9 through employer B? Or is it already effective from the date of H1B approval? It is effective from the date of H1B approval. And you should not be working on L1. So this is a totally different situation from the previous one. Here you got a change of status. Okay. So when you have a change of status, it becomes effective upon approval. What should you do? Well, technically you have violated status if you have worked on L1 when your H1B was already approved. Okay, because employer B shared the approval notice with you on 29th. So for 8 days you were working, I guess, or even longer on L1 when your L1 is already over. Is this going to be a big deal? Well, if, like I said, technically you have violated your status, in a perfect world, you should go get your H1B visa stamping and come back. That's all you have to do. And that's easy enough. Okay. *5 if you have a follow-up question. Is there a time limit within which I must resign? Well, you are already working without status. Your L1 is over when you get a change of status. So the earlier you resign, the better you are. Okay. No questions. Let's go on to the next frequently asked questions. Can certifications and courses qualify me for an H1B? So here we have somebody who's got an online 6-month course in management domain, but they have a degree in chemical engineering. So the question is, can these certifications and extra courses I do in management, can they get me an H1B visa as a manager? The answer is not really. Why? Because these courses are not considered to be bachelor's degree. And in any case, bachelor's degree in business may not be enough to be a manager. Even MBA is questionable. Management is a very, very dicey field for H1B. Okay. What could help is, if your management job required a degree in chemical engineering, you have a master's in chemical engineering. So what if you were managing a company that is involved in chemical processes or pharmaceutical processes, where a degree in chemical engineering is required for the job. So even though you're a manager, you're a technical manager, you're a technocrat. So the answer, can these certifications and all help? Probably not. But can having a degree in chemical engineering qualify me for a manager's position? The answer is maybe, based upon what I just told you. Let me see if I covered all the question. Yes. So Anusha, if you have a follow-up question, press star 5. If you are here, have a follow-up question, press star 5. Okay. Next question. Okay, these are all the frequently asked questions. I think one question I had to take offline because it was just so detailed, and I think I have notified you who wrote that question. You need a personal consultation either with me or with your own lawyers. I can't really answer that question in that much depth. I have to talk with you in detail. Let's go to the questions that are not frequently asked questions. Okay, the question that I deleted was this question, which was, I don't know who posted this question. Oh, sorry. I just went up one. So whoever you are, I actually did send you a notification through the system. Okay, going back to non-frequently asked questions. Flower Girl, A2 visa and filing adjustment of status, DV based. Okay, so I don't know anything about diversity visas. We don't do lotteries. I don't think you need a lawyer for lotteries. And I'm trying to remember the process of an I-566 because we do it for G4 visas all the time when G4 is converting to H1 or green card. So the way this works is we get the I-566 processed and attach it to the paperwork. Okay. So I believe that's what you have to do. But I also remember there was some provision for submitting I-566 when I get an RFE. Okay. Here is the easiest way to figure this out. What you do is just go to the Human Resources website for the World Bank and look at the process for I-566. I don't remember how it works, but they have very good explanation of what they do. And it's the same process for consulates as well. Okay. Star 5, if you have a follow-up question on this, star 5. All right. Next question. Okay, all these were frequently asked questions. We covered these. Of Ignatius' question I already covered. This one I covered. So EB1A, Extraordinary Ability Green Card category. Doing PhD in blockchain, published several papers, working as a program manager, making several meaningful contributions in the state and federal government sectors, impacting the lives of K-12. Yeah, I can take a look at your resume. It does look interesting. You can send me an email to help@immigration.com. I'll take a look at it. But see, I can see that potentially you could argue for two factors right away. And if you happen to be not born in India, national interest waiver is also a good category to think about. But if you're India born, then EB1A, it should be considered. I can't tell, I need to look at the whole resume. And we don't charge for that, so you can send me your resume. If you have a follow-up question, press star 5. Okay. H1B visa extension with approved I-140. I wanted to take a break, apply for H4. So you want to go from H1 to H4. Considering the processing times, well, now the processing times you can do starting June, you'll be able to do premium processing even for H4. Okay. So starting June, this question may not be relevant anymore. Yeah, and you can't, if you go to H4, you can't start working on an H1 until it is approved. So I think the easiest thing is just to premium the H4, or you can go outside, get an H4 visa stamp and come back and then apply for H1. Okay, I hope that helps, KK. *5 if you have a follow-up question, press *5. Okay, next one is SNAP. So food stamps have been exempted by the government, so I don't think you should have a problem. Mother is on green card status. She received food stamp benefits every month. I don't think that's a problem because the government has said that they will not consider SNAP to be a negative factor for public charge determinations. You can actually Google this. You can Google USCIS, SNAP in all caps, public charge, and they should pull up the page for you. Okay. *5 if you have a follow-up question on this, press *5. British citizen, first class. By the way, for green cards, it is not the country of citizenship, it's the country of birth that matters. I'm a British citizen, first class undergrad PhD degrees. I have high impact journal publications, awards, patents. You too can send me your resume to help@immigration.com. I'll take a look at it. Okay, that looks like all the questions that had been posted. I'm going to close the conference and start new questions. You guys can raise your hands. If anybody has a new question, press *5. Any question, press *5.
The conference is now locked.
Okay, I locked the conference. There's only one question? Wow, that's an amazing day. So many people in just one question. Okay, good. Let's do this. Texas, I can hear you. Go ahead with your question, please.
Hi, good morning, sir, and happy new year. So, yeah, my question is that when can I get into the green card waiting queue? When can I get the green card wait time? And when is it okay to change the employer
Okay.
and still not reset the green card waiting time?
No worries. Are you what are your degrees? Do you have a PhD, master's, bachelor's? What is your degree?
I have done my master's and recently I got my H1B approved.
Okay, good.
And the company also filed for my term processing. So, yeah.
Okay, so that's easy to answer. So the way this works is your priority date is the date your perm is filed. That will take about 7-8 months from the day you get started. So once the perm is filed, that becomes your priority date. Once the perm is approved and the I-140 is approved,
Okay.
even if you change employers, you will carry your priority date to the next employer. That means when you go to the next employer, you will start your green card again, but it will carry the priority date of the old green card. So let's say, give you an example. In 2023, your perm is filed. In 2024, perm is approved, I-140 is approved. In 2024 itself, after the I-140 approval, you move to a new employer who starts your green card in 2025. So even though they started your green card in 2024, your date will be 2023, which is the first employer's perm filing date.
Term filing date will be the green card priority date.
That is your priority date. But only if the I-140 hang on. Only if the I-140 gets approved. If the I-140 doesn't get approved, then you got nothing.
Got it.
Make sense?
Understood. Yeah, makes sense, sir.
All right.
Yeah.
Well,
So I have one more doubt. What are the risks when we start a PhD on H1B versus when we get a green card and then start a H1B?
there is no risk. There is no risk because H1B allows you to go to school simultaneously. That's not a problem. So
Okay, but if I stop working altogether and then take up the full-time PhD?
you can't do H1B. You have to go to F1 then.
Or H1B ends as soon as I begin my PhD. You know?
Yeah, so let me give you an example. Today, you got admission in MIT and you are working full time under your H1B and you are going to school part time, obviously, because it probably is not possible to do both full time. But let's say a year down the line, you want to go to school full time. Now, at that point, you'll have to convert to F1 because you'll have to resign your job. But one thing I haven't really looked at very carefully is, can you have a part-time H1B and go to school full-time? I think you can. But I have to confirm that. I have to look at the law. So the choices are, if you want to go to school full-time at some point, see if you can convert to part-time H1B. I think you can. And go to school full-time while still on H1B. And the other choice is to convert to F1 and go to school full-time.
Sir, if I convert to F1 and then because I had an H1 before and when I get a job here, can I transfer the old H1 to that new employer directly?
Yes. For the next 6 years, you will not be subject to H1B quota.
Okay, understood. So it's like as soon as I finish my PhD and if I get a job, I don't need to worry about H1B lottery again, right?
Absolutely, absolutely, no problem. No problem. One more thing I want to add. But let's say you have a degree in chemical engineering, but you do your PhD in information systems because the school allows you to. Can you get H1B quota exemption for a job in information systems even though your first H1 was for chemical engineering? Yes. It doesn't matter if you change fields. Okay?
Sounds great. Yeah.
All right. Good luck.
Thanks.
Oh, you're welcome. You're welcome.
Thank you.
Okay, ladies and gentlemen, this was an unusual day. We started late, but we finished very, very early. Good to see you all. Take care, and I'll see you again. Two more questions. What were you waiting for, you guys? One more question. Okay. Go ahead, Texas. Okay, no, I guess they raised their hand by mistake. All right. I'll see you guys again in 2 weeks. Be well, everyone.